Okay, sige. Before we start, I ask everybody for a short prayer. In the name of the Father, and the Son, and the Holy Spirit. Amen. Dear Lord, we thank you for your guidance, your providence, and your love. We continue to pray, Lord, that we discover our potential, our skills, and enhance our competence with new understandings and learnings. And as always, Lord, we pray that we may apply them all for your greater glory. This we pray through Christ our Lord. Amen. Saint John Baptist de la Salle,
Pray
pray
for
for
us
us, leave Jesus in our hearts
forever.
forever. In the name of the Father, and the Son, and the Holy Spirit. Amen. All right, mayong hapon sa tanan. Let me resume by sharing to you. Again, I'd like to clarify ha kay basi ang iban sinyo wala pa ka remember, we're not gonna have our exams for next week. We're gonna try to catch up with all the other backlogs discussions that we'll have. Okay, so by now, I hope that you're already aware of the different sources of obligation. So you know that you have the law, you have a contract, quasi-contract, you have the delicts, and you have with you your quasi-delicts. Actually, again, the whole point is that the source of contract belongs to only two, law and the sources of obligation belongs into two, under the law and what is found under the contract. When you're talking about delicts, these are laws or these are acts or omissions punishable by law. So it's still the law that is going to be the source of your obligation here. Quasi-contracts, it's provided for under your book 4, series of them that states what governs the relationship under negotiorum hesio and solutio indebiti. So therefore, it's still under the law. Now, in contracts, it's what you will agree upon that will be the source of your obligation. Okay? Sige. Let me... there you go. Share ko lang, ha? Okay. There you go. Here. So, so the sources of our obligations, you have your law, your contract, your quasi-delict, your delicts, your quasi-contract, and all of that. Ex lege, meaning coming from the law. So please take note, what is the characteristic when the obligation arises from law? It does not need the consent of any of the obligor or the debtor because it is imposed by law. Another instance of your talking points here is that it must be expressly provided for the law. I have always emphasized that the law must be there and it should not be presumed that an obligation is being created. So in order that the law may be the source of the obligation, it should be the creator of the obligation itself, meaning the law is the one that is granting for the obligation to be part of. So say for instance, under Bayanihan 1 and Bayanihan 2, the administration is here duty bound to provide assistance through social amelioration programs for families that have been affected. So an obligation to perform or giving out the necessary funds for the people. That is an obligation arising from law. So what governs obligations arising from law? It is the law in itself. Civil code is only a suppletory, meaning it's through its assistance. These obligations will be regulated. So again, sources of obligations, this time under ex contracto or obligation under contracts. What is the requisite? First, it must contain all the essential requisites of a contract. Discussing ahead from 1305, elements of a contract requires consent, object, and consideration. So there must, and in particular, in addition to what that requirement, there ought to be what? No provision that is contrary to law morals, good custom, public order, or public policy. For instance, I enter into a contract between a minor child, that the minor child will be my wife. That is against our laws on public policy, because family code dictates that 18 years old is the age of majority, or one to be able to enter into a contract. So that contract I entered into with a minor is an invalid one. Okay, so there can be no obligation being created there. Just a review under your family code. Of course, when you enter into a contract of marriage, the marriage will then be create certain obligations, such as what? Affording each other mutual love and respect, providing support for each other, and at the same time, fidelity. So these are instances of which the obligation arises. There is an obligation to give, which is an obligation to give whatever it is that you have in support of the other spouse. There's an obligation to do. The obligation to do is to render mutual love, support, and whatever affection that you can give. And there's an obligation not to do, and that is to cause infidelity or to find another. Okay, so the whole package of prestation is found under your contract of marriage. Now, again, sources of obligations under ex contracto. What is compliance in good faith? This is a term that is actually used in obligations wherein you must perform the obligation according to the stipulations, according to the terms or to the conditions that the contract is being provided for. By instances, some of the provisions may not, some contracts may not provide all the provisions therein. So there is going to be a challenge to that individual. But so long as you intend that no harm, no foul, no injury is to be made to the other party, then that is the essence of compliance in good faith. That you perform everything according to the intentions or what is stipulated to the terms of your contract. Okay? So please remember that a contract is the law between the parties that have entered into it. Now, particularly, may a party unilaterally evade his obligation in a contract? What's your answer? The answer is, general rule, neither party may unilaterally evade, meaning avoid or not perform his obligation under the contract. But it is subject to an exception. The contract authorizes, meaning the contract allows it, or the other party actually consents. It may not be found in the provision, but say for instance, ang other party just simply agreed na lang, meaning there is a novation or a new contract entered into that actually allows the other party to not perform his obligation therein. But these are more or less the exceptions. The general rule is that to ensure that the contract is the law between the parties, ito ang batas nating dalawa, dapat sundin ang batas. No one can evade the performance of the obligation. Now, still under ex contracto, is there a limitation on the rights of the parties to freely enter into a stipulation? Generally, yes. Parties may freely enter into a stipulation provided that it is not contrary to law, morals, good customs, public order, and public policy. Say for instance, I have a house, I want you to rent my house. And in renting my house, we just agreed into the contract of lease the duration. You will occupy my house starting October 8, 2021 and end on October 8, 2022. 1 year. Then the next stipulation is that you will pay me 10,000 a month for your rental to my house. That's the only terms that are provided there. Then it so happens that when you occupied my house, what you did is that ginghimuan mo siya drug den. Ginghimuan mo siya laboratory for making shabu and all other illegal drugs and substances. Then I told you, get out of my house. And you told me, wait, we have a contract. Our contract states that the duration ends until October 8, 2022. You did not say there that I should not do this. Here is the nature of contracts. Again, it is to be assumed that the law is deemed written into the contract, meaning to say that even if the stipulation for you prohibiting you from doing illegal activity is not written into the contract, the law is deemed written into the contract, meaning that when it violates laws, morals, good custom, public order, and public policy, it may void the said existence of a contract. Okay? So, muna kisa ang argument sa iban, wala niya sa kontrata ta. But again, the incorporation of law, which is the necessity to follow, even if it is not written, is actually deemed written in the contract of the parties. So please be aware of that. Then, what governs obligations arising from contracts? It's actually, these are governed primarily by your stipulations. Kung ano ang nasulat, ano ang na-provide, ano ang terms, ano ang mga conditions nyo. But of course, there are exceptions. The contracts with prestations that are unconscionable or unreasonable, they cannot be deemed written there. So in cases of unconscionable penalty for breach of a contract, unliquidated damages, the same is actually for the court to intervene. Let's just expand lang niya. We're expanding. Actually, dapat na-discuss na eh. I'll just reiterate na lang yun ang mga concerns for sources of obligation. Ex contracto, what does this mean? These are contracts, again, that are like contracts. You did not enter according to an agreement, but because of circumstance, they will be imposed upon you. These are lawful, voluntary, and unilateral acts based on the principle of what? There should be no unjust enrichment at the expense of another. So that's the bedrock of quasi-contracts. So in quasi-contracts, there is what we call presumptive consent. Meaning, when you perform something, you allow that person to perform that act and you did not, kumbaga, contest. Such is a way for others to interpret that you have given your consent over it. So because a quasi-contract is a unilateral contract, it is created by the sole act or acts of the gestor or the one performing it. There is no express consent. Again, the example that we have usually is the officious manager, meaning it benefited you when he took care of your farm, fed your animals, gave them sufficient water, resources, and even housing. You have the obligation to repay or reimburse the cost of whatever expenses that was given because it benefited you. So in that instance, a quasi-contract is actually being created. So what are the principal forms of quasi-contract? You already know this. There are only two. First is negotiorum hestio, and then solutio indebiti. Solutio indebiti, this one takes place when a person receives something from another without any right to demand for it, or the thing was unduly delivered to him through mistake. Say for instance, ang balay nyo is 50, unit 50. Ang tupad balay nyo is unit 50A. Nag-abot sa inyo si Food Panda, tapos pizza. Paghatag sa imo, ging receive mo, you have no right or whatsoever to demand or to receive it. Pero gingkaon mo lang siya, kaya abi mo, imo na. And then later on, it was found out that it was supposed to be for unit 50A. There was a demand that you repay or reimburse it, and you said, no, I will not do that because finders keepers. No, the law actually grants those who have been unjustly affected and you who have unjustly enriched yourself to have an obligation to repay, to return, or in whatsoever form provide the appropriate payment or equivalent in money or in function of that service that you acquired without right. Okay? So, negosyorum hestio naman niya, or the inofficious manager, again, that example I gave you. When someone voluntarily takes care of your property or your business, even without your consent, then you would eventually be the one who needs to take care and repay for that. Okay? Muna gani kisa, in all honesty, may ara na da alam ng mga gabantay bala sa may redemptorist kung mag-park ka. Kay di bala gapa-park na sila tapos ibilin mo sa lakyan mo sa may parking lot ng iban sinada. Tapos mambal sila, "Sir, bayad kay ging tinluan ko or ging care ko ang imong salakyan and all." Tapos gambal ka, "Wala man ko nagsugo sa imo. Wala man ko naghambal sa imo." Then sabton ka lang, "Sir, may ara ta quasi-contract. Ging himo ko nga nakabenepisyo para sa imo." And then sa imo nga ulo, grabe nag-alam, nag-eskwela gid ni siya guro, pulsay ni siya guro ang estudyante ay. Pati kamo mga abogado for that. So you're gonna defend the very right to ensure that everybody knows and understand na you can actually demand from another the very right of what is equivalent to the benefit that the other receive under quasi-contract. Okay? Now, negosyorum hestio, I'll skip that because that's an example from the book. Here, upon learning what happened to his house, X sued X for damages and pleaded as a defense that he merely took charge of his house under the principle of negosyorum hestio. He was not liable for the burning of the house is a fortuitous event. Is why liable for damages under the foregoing circumstance? Because the story here is that by state of necessity, kumpul-kumpul, pasunod ang mga balay. And then, ang house 1, 2, 3, 4, ikalima nga house ang imo. Sa house nga ikalima, nakita mo na nga nasunog na ang house number 1, house number 2. Or affected na siya. What you did is you destroyed house number 3 so that hindi na maglaptas sa 3 and 4. Usually, that's also an example of negosyorum hestio. Because 4 and 5 benefited from that circumstance of rescuing or blowing up the third house so that hindi maglapta ang fire, they have an obligation to actually repay for the damages for what has caused to house number 3. Okay? So that's simple analysis of negosyorum hestio in terms of who gets to be benefited from doing something. Okay? Right. This one's different. Yeah. So Y is not liable. Furthermore, B is not liable to A for fortuitous event because he did not commit any of the instances. So he did not take risky operation. That's the bar question actually. It's not assumed management and bad faith. So let's skip those. What is the legal effect? Solution indemnity. Here's an example. X receives his full retirement benefits, including those monetary benefits that were properly disallowed by COA to be granted to a public officer. So GSIS, the one that gave him that benefit, sought the restoration, bawion ang mga disallowed benefits because the court ruled that such restoration cannot be given to X for his retirement because it's prohibited under the law. X is X obliged to return the benefits improperly received by him under the principle of solutio indemnity? Answer: yes. It cannot be denied that X was a recipient of benefits that were properly disallowed by COA, meaning it should not be given or granted to him. These COA disallowances would otherwise have been deducted from his salaries. So there is no longer the right to recover. no longer the right to recover this amount by any administrative due. So X resultantly retained benefits to which he was not legally entitled to. That's again the same principle. You cannot retain something that you are not entitled to. Now, sources under ex delicto. What is the basis of civil liability arising from delicts as according to the Penal Code? This is found in Article 100 of your revised Penal Code, meaning that every person who is criminally liable is also civilly liable, that which arose from the criminal liability. Okay? Now, what is a delict? This is what is found in your revised Penal Code, diba? Acts or omissions, they are punished by law. Where do you commonly find them? Revised Penal Code. Now, what is a quasi-delict or a tort? They are committed by reason of, number one, negligence or by fault. There is damage and there is no pre-existing contractual relation between the parties. These are acts or omissions causing damage. How is damage caused? Because of fault or because of negligence. There is no pre-existing contractual relation. So what are the elements? Usually there's an act or omission, there is damage, there is negligence and fault. There is a direct cause between the damage and the fault, meaning the proximate cause is the negligence or that of fault causing the damage. And there is no pre-existing actual relation. Munisyo lang example ba lang kung negligent ka nga driver sa dalan, sagi ka cellphone, ga-drive ka, nakaipit ka, you will eventually be held to liability to pay for the person that nga naipit mo. By reason that you committed an act, it was through negligence, definitely because naipit mo siya, may damage ka na cause. Ang relations ng imong negligence that caused to the injury is the proximate cause, and you have no pre-existing contractual relation to that person nga galabay. Okay? So these are instances of which you will have liability. Okay? I'll go now to discussing I'll go now to the discussion on solidary and joint obligations. I promise to open that up. I'll just skip. Okay, here it is. I'll discuss first ang divisible or indivisible obligation para masapwa sa inyo. Light lang siya. Okay. Here is the discussion for divisible and indivisible obligation. So divisibility or the indivisibility of things which are object of the obligation. Take note that we're under the third element that is involving the object or the prestation. Okay? Kaya mabalik lang kita sa discussions ng elements. We're just expanding the coverage for it. So divisibility or indivisibility of the object of the obligation, where there is only one debtor and only one creditor, this will not alter our concerns for the rules. Meaning, here, there is a need to deliver or to perform. It can be divisible or it can be indivisible. What is the objective here? The object of which it is to be delivered or performed is capable of partial performance or it is not capable of any partial performance. Now, how do you test this? The test of distinction is actually the purpose of the obligation. It is not just the possibility or the impossibility of partial prestation. Meaning to say, we know that a certain object can be subdivided, even can be cut off, can be kumbaga, broken down into pieces. But you will need to look into what is the purpose of the obligation. Even if the object or service may be fiscally divisible, you will still need to look on the intention of the parties. The party's intention is the one that will control whether it is divisible or indivisible. So, same that if an obligation is indivisible when it is so intended by the law or by the parties. Now, in moving to the discussion, what is the test of distinction? Again, it is the intention. The intention of the parties will not be the controlling to make the indivisible divisible. Why? The obligation will always be indivisible and the rule is absolute. Meaning to say, an object in its default is to be intended as indivisible. Okay? The intention of the parties will not control in trying to make an indivisible object to a divisible one. That is the pronouncement under your civil code. But the intention of the parties will not control in trying to make the indivisible obligation to be a divisible one. The object again is, if the nature of the object is such that it cannot be subdivided or cannot be broken down, it has to be an absolute rule. Here, an obligation is presumed to be what? Indivisible, where there is only one creditor and only one debtor. There are things that refer to the object or prestation which may be delivered or performed such thing and render something in service of another. So say for instance, D agreed to pay C 10,000 in 4 equal monthly installments. The obligation of D is divisible because it is capable of partial performance. But if the agreement states D will pay C on a certain date, the full amount of 10,000, then the obligation is actually indivisible. Although money, again, is physically divisible, but the intention of the party is what the obligation must be fulfilled at one time and as a whole, then take note, it is indivisible. The underlying factor here is that it is performed or fulfilled at one time and as a whole, indivisible na siya. Divisibility of an obligation should not therefore be confused with divisibility of the thing, which is the object thereof. Divisibility of an obligation, whereas the divisibility of the thing. Meaning, divisibility of the object. Pwede siya tenderloin, pork chop, tanan, everything. Divisibility of the thing, though it is possible, will always be dependent on the intention of the parties. Further example, S obliged himself to deliver to B a specific car on November 15. This obligation is indivisible because it is not capable of partial performance. Imagine if S will deliver first the tires, next the handbrake, the steering wheel, and all of that. So the car must be delivered at one time and as a whole to B. So S deliver a 1/2 of the car, on the other, on 15, naturally, B will not agree. Assume B agrees Will the obligation be a divisible or indivisible type of obligation? The answer, it is still indivisible. Okay? Because, again, the nature of it is it is the absolute rule that there is an indivisibility of the obligation. So S must deliver the whole car either on November 15 or November 30. The only distinction is that it is made on a different date for the delivery. Okay? Pwede mo ma-deliver ang due date sa 15 or sa 30. Okay, deliver ko sa 15 kag sa 30. Tina-deliver mo na sa 15, ma-deliver ka pagid sa 30, na-deliver mo na gani sa bilugan. Because again, it is an indivisible type of obligation. Lain naman niya ang indivisible object. Okay? Obligation versus the object. Ang object yan, the thing, the nature lang. That's why I was very keen in particular that you get to understand this part. Divisibility of an obligation, divisibility of the thing. Thing ni siya, which is the object. The obligation naman niya is the very nature. You include the date, the maturity, you include the parties that are involved in the obligation, you include all the variables needed for it. While the divisibility of the thing, you can either attach it as, okay, the object can be divided into, but the obligation requires it that you have to fulfill it in whole and in one point delivery of that thing on one particular time. So here, a definite thing like a car cannot be served into parts without altering its essence or destroying its value. It is an essential condition of the fitness of a thing to be divisible that it is possible, by uniting the diverse portions thereof, to reconstruct it as existed before its division. So, meaning to say, it is very much important that you get to understand the essence and the value of the thing. Kay may ara ng the more that you divide the thing, the more that the thing loses its value. So division may either be qualitative, one based on quality, not on the number of the things which is the object of the obligation. And then the division could either be quantitative, based on the quantity, rather on the quality. Sila quality ni siya. Quality. Ideal, intellectual, one which exists only in the minds of the parties. So these are the divisions that are actually imperative that you get to know. So in the death of one person, he owns, say for instance, a house, appliances, a farm lot, a car, and money. These are various objects under the estate of one person. In a qualitative division, one based on quality, not on the number or quantity of the thing. So A and B are heirs of C. They agreed to divide their inheritance as follows. A will get the house and lot and home appliances. B, rice field, the car, and the 100,000 cash. That is a qualitative, not based on the quantity. Okay, you know the distinction between qualitative and quantitative. In instance naman niya, rice fields, because of their value, may ara gid ni siyang vast tract of land. Here, one is facing the road, the other one is facing the hacienda. So, in instance, pamilya, one would prefer the lot that is near the road, while the one inside the hacienda, maski ano mo pa kadako, ang value niya may not be as promising as the one facing the road. So kinds of division. Quantitative, division based on quantity. So A and B, who are the heirs, the inheritance consists only of a rice field. While they were trying to partition it with the meets and bounds into two equal parts in quantitative. The upper half in the rice field facing the road. The lower half, the rice field inside the hacienda. When A and V divided the kavans of palay harvested from the rice field, or they get the 100,000 in cash. Take note, you may divide it, just as an example. Pareho ang ilang share. Ang values ng isa, let's just make the assumption that both of them are 1 hectare, 1 hectare. They are located on a different location. One is near the road, the other one is in the hacienda. So the portion lang yun sinada, pag divide mo, technically, 1 hectare, 1 hectare divided, they are equally owing the same area, quantity. Okay? But its quality may be different because the one facing the road could have a fair market value higher than the one located inside the road. So qualitative, meaning same number, meets and bounds, 1 hectare, 1 hectare, but it does not have the same value as in qualitative. Sige. So, example. Sorry. This one is the intellectual kind. In the intellectual division, 1/2, si A and B are the heirs again of the dead person here. 1/2 of the rights to the car, A gets it. The other half, the rights goes to B. 1/2 of the rights in the rice field, the other half goes to the rights of the sibling. Here, there is an ideal or intellectual division. One which exists only in the minds of the parties or to the intention of their, decedent, ang tao nga napatay through the will. He's giving it. A and B are heirs of C. The inheritance consists of a rice field and a car. It is not partitioned by meets and bounds. Usually, di ba, kapos nila ng imo na ng salakyan, ako na lang yung rice field. So 1:1. You have 1 car, I have 1 rice field. But that's not the perfect world because the value might be higher in terms of ang presyo bala, ang rice field is mas mahal. Ang car, pagalpalo na siya. So hindi siya ideal. But no material partition, but only a mentally one done under the law. Technically, all the property that has been left out by, say for instance, ilan ni siya nga tatay, they get to share that half by half. If they are the 2 remaining heirs, they only get half of it. So A will get half of the rice field, and B will also get half of the rice field. Same as half of the rights to the car, half of the rights to the other car for B. Neither one can say that he is the absolute owner of a specific portion of the rice field or of the car. Because, again, this is an intellectual division. The intellectual division is the one that is predominantly required or being adopted under our laws. Kung mapatay ang, say for instance, the parent of one, it is divided equally to the children involved. And when it is divided equally among the children, then rights are only distributed, not the entire property. Ganyan nga i-divide. Okay? So that's the intention here. The intellectual divisibility under our civil laws. Now, so again, what are the different kinds of indivisibility? It is indivisible because, number 1, the law states that it should not be divided legally. It is indivisible because the parties agreed you should not divide it. Or because the very nature of the thing, it cannot be divided. Yun yung mga examples. So, legal indivisibility where a specific provision of law declares that one or that obligation, and by its nature, is one that should be considered as indivisible or divisible ba siya or hindi. Conventional naman niya, as what I said, if it is agreed by the parties, if it is agreed by their intention, then it will assume the nature of being divisible or not divisible. Natural indivisibility, where the nature of the object or prestation does not admit any kind of division. So may ara na siya nature of the thing. Applicable, but it involves only one creditor and one debtor. So rule here. Exception. The debtor may not perform the entire obligation if there is an express stipulation to the effect. And on the other one, the obligation is not being paid unless the thing or service in which the obligation consists has been completely delivered or rendered, as the case may be. Meaning to say, when you are trying to fulfill your duty as a debtor, you have to do it in whole, but not necessarily at one time. Say for instance, I owe you 10,000 pesos. I do not have 10,000 pesos. But what can I do for you? I can paint your house. And in doing that payment, I am rendering the equivalent of my work in exchange of the value of that 10,000. The obligation is not being paid if I have not finished the entire house being painted. But I can go separate days or separate weeks or separate months just to finish the working of the painting of the house. So meaning to say, under our laws, I am not bound to perform the entire obligation at one point at in one time. Because it may not be realistic that mapatay ko ya bilog nga day lang ko, gapaminta lang ko, ginahaklo ko tanan nga pinta, ano na yaman? So there are instances of which the law also considers that, well, the obligation may not be performed in its entirety in just one sitting. But the law also considers that you are not to be considered paid unless you fulfill the complete delivery or the complete performance of the obligation. Okay? So that's the limitations there. These are the rules that you have to follow. So, rule number 1. Ang divisibility or indivisibility applies to the object or prestation. It does not alter or modify the provisions said under 1223. What is 1223? I'll go to 1223 for your convenience. Wait, and ano show. 1223. You have your civil code with you? Wala? Okay. I'll open the civil code. Wait, ha? Here's 1223. The divisibility or indivisibility of the thing that are the object of the obligation in which there's only one creditor and one debtor does not modify the provisions of Chapter 2, which is already the provision containing divisibilities of obligation. Yes. So meaning to say, the rules are just simply there stating that, number 1, the nature of the divisibility is compounded. Here, rule number 2. When there is only one creditor and one debtor, the debtor has to perform the obligation in its totality, whether or not the prestation is divisible. So, kung ang performance of the debtor is to deliver a particular object, he has to deliver that particular object at one point and at one time. Even if possible nga 50 sacks of rice lang anay ang i-deliver niya, but the law presumes that he has to perform it right away and at one time. So again, I entered in a contract with you. Imagine kamo ang creditors ko. I'll deliver 100 sacks of rice to you. The rule found is that though we may not have provided how I am going to perform the obligation, the presumption of the law is that I am going to do it indivisibly, meaning at one point. So if I promise 100 sacks of rice, I will need to deliver that 100 sacks of rice to you, whether the prestation is divisible or indivisible. Okay? So that's rule number 2. The assumption is always it is the indivisible. Performance of an obligation is indivisible. Let me tell you the logic for it. It will be very inconvenient on the part of the creditor. You know, diba, the creditor is the active subject, the one who has the right to demand. If the performance of the performance or delivery of the thing is going to be divided pa, it will be inconvenient on his part. It would be very costly if he is being prejudiced by this. Why? Because later on, we're going to talk the very concept about delays or mora. Technically, you will be held in delay if you have not performed the obligation. Others would claim that I have performed the obligation, but I have only performed it partially. Partial performance is no performance at all, yapon. So that should be the objective. Still part under rule number 2, except the debtor may perform the entire obligation if there is an express stipulation to that effect, or he may perform not the entire obligation, meaning half of it, if allowed to, under 1248. Rule number 3, the creditor cannot be compelled partially to receive the prestations in which the obligation consists. You cannot tell, ari na gid ning may-ari ko din nga 50% lang, oh, ano ni kay magasto ko pa ni karon. The rule is that the creditor may validly or legally or justifiably refuse. Why? Because again, the rule is that perform or no perform at all. Give it all or not at all. Okay? So obligation is not deemed paid unless the thing or service in which the obligation consists has been completely delivered or rendered. So this is the rule that we're trying to emphasize. Obligation is not deemed paid unless the very thing or the very service is completely rendered or completely delivered, as the case may be. Now, the discussion about joint indivisible obligation gives rise to what? Payment of indemnification or damages from the time any one of the debtors does not comply with the undertaking. So there can be instances wherein, di ba, the premise ng previous one under 1223 is that one debtor, one creditor. Mag-evolve ta, damuon ta naman ang creditors or damuon ta ang debtors, this case. The debtors who may have been ready to fulfill their promises shall not contribute to the indemnity beyond the corresponding portion of the price of the thing or value of the service in which the obligation consists when they are already ready to perform. So again, this is the scenario. Joint indivisible obligation, they give rise to indemnity from damages from the time any one of the debtors does not comply with the undertaking. Meaning, damo kami mga debtors. Damo kami ang dapat ma-deliver, ma-supply, ma-perform sa isa lang ka-creditor. In usual sense, and under the law, if all of us are supposed to render the service in one point and in one time, Those who are ready to fulfill our promise, those who are ready to deliver. Kasi siyempre, ako, ako, si B, si C, A, B, C. Kami ni A kag ni B, pwede na kami mag-deliver. Si C, hindi. Example niya, kung magpakasal ka mo or may party ka mo da. Joint obligation is that tomorrow birthday. Sa birthday, may ara ako caterer. May ara ako ging kontrata naman for photography. May ara ako ging kwa entertainment. Bundled ang package siya. Different roles. May isa para sa catering, food of course ready. May isa para sa photography for documentation ready. May isa para sa entertainment, makanta, ma-perform na siya, ma-clown na siya, mabada siya, ano na gusto niya, basta may entertainment. They are joint indivisible because on the day mismo, alangan man nga mapakaon ka after na sang party. Imagine na, ready na si photographer, ready na si entertainer. Ang food, which is the very important one, hindi pa ready. Here's the scenario. The debtors who may have been ready to fulfill their promises, they are the ones who shall not contribute to the indemnity beyond the corresponding portion of the price of the thing and the value of the service in which the obligation consists. Package ni. Package is 50,000. May food na, may photographer na, may entertainment na. Pero sa nabila sa natabo to sa Cebu, kulang ko no, basta something like that. But the entire idea here is that kung hindi sila mag-perform, it corresponds to a liability for damages. Pero ang mabayad sang damages is the one who is not ready to perform. The other two, again, I'm looking into this provision, the second one, the debtors who may have been ready to fulfill their promises shall not contribute to the indemnity or mabayad beyond sa portion of the price or the value. Yes, Angel, you're raising your hand.
Regarding the sabing discussion, may nakita ng article sa Facebook. Ang tuloy ko na share akong screen.
Sige, Beck. Wait, ha. Pa-share ta ka. Sige. Wait. I'll assign you. Wait.
Ang aral sa atin na.
Wait. I'll make you a host. Ayan na. Wedding photographer. Oo. Tapos wala siya gipakaon, ging delete niya. Oo, kita ka na.
Direct ang contract na sa atin eh.
Huy. Way ka lang gipakaon, hindi mo na pag-perform obligation mo. Ano na yan? So, ang initial nga example mo na di siya is, say for instance, a contract of service. Your contract of service and the delivery of the photographs nga ging himo mo. So in that instance, actually, you would look at it as a breach on his part for not being able to deliver the object, which are the raw and soft copy. Tapos, kung wala man lang siya ging pakaon, I do not know if there is an implied sinadaha. So nagsimula siya ng trabaho bilang official to alas 11 umaga hanggang alas 7 ng gabi. Tapos pagsapit ng alas 5 ng hapon ay kumain ang mga bisita, kaya nagpaalam ito sa groom na 20-minute break muna para uminom ng tubig at makakain. Ngunit hindi ito pinayagan ng groom at nagbanta pa na hindi babayaran. Kaya sa sobrang inis, nag-walk out na wala ng photographer, tapos wala na siya. Tingin na siya breach, ginaya nga klaro. Wala pa gani. Just because he was not being granted to eat. Kaling of course, pwede niya na kung wala kaging pakaon, siyempre mga kagid man. Pero not to the extent nga hindi mo pag-i-deliver ang imong obligation. Alright. Sige. Thank you, Angel. Ka-funny mo naman. Kilala mo na?
Hindi, nakita ko na.
Sabi ko sa imo ni nga kasal kay do affected kagid. Basta sa imo ni nga kasal, imbitaron mo kami sa kasal mo ha. Anyway, sige. Let me continue with with that discussion. Lapit naman na niya. So here, effect of non-compliance by a debtor in a joint indivisible obligation. So if one of the debtors does not comply with this undertaking in a joint indivisible obligation, the obligation is converted into one for the payment of damages, or you pay the equivalent of money. The creditor cannot ask for specific performance or rescission. Specific performance means that you are being compelled to perform it. Ang rescission is the cancellation of the contract, or one wherein you return each other to the previous state before you entered into an obligation. Because again, there is no cause of action against the other debtors who are willing to fulfill their promises. Mas ideal ni siya if you get to discover the functions of joint and solidary obligations, which is actually the next topic. So here are some of the rules that are deemed indivisible. Obligations that are provided for by law, payment of taxes. It should be paid within a definite period. Although money is physically divisible, the amount of tax paid must be delivered in toto and not partially. Imagine, mabayad ka tax, sa balon mo, 5,000 lang ang bayaran, tapos lason lang ang 500 million. Okay, so medyo hindi na siya reasonable. For the purpose of the preceding articles, obligations that give definite things, and to those which are not susceptible of partial performance shall be deemed to be indivisible. And when the obligation has for its object the execution of a certain number of works or days, meaning may ma-perform ka and you're indicating numbers of days, the accomplishment of work by metrics or analogous therein, or the nature are susceptible for partial performance, then it is to be understood as divisible. Basta gani kung i-perform mo siya, may number of days pa nga i-render mo, and then ang units, ang i-give mong item is measured in units, or in some analogous instance, these are your clues, ladies and gentlemen, that the obligation is divisible. However, there is a caution here. Even if the objects or the service may be physically divisible, an obligation is indivisible. So again, if this is the intention of the parties or that is provided for by law. In obligations not to do, divisibility or indivisibility is still determined according to the character of the prestation. So a house and an electric fan. Obligations here. To give definite things, the nature of the subject, to give a particular electric fan, or to deliver a specific house, or those not susceptible for partial performance. Maybe the reason is for its purpose. It requires performance of all the parts. Kabudlay man nga magamit ka sang electric fan nga wala pa siya sang LEC. So that should not be the case. In a performance not susceptible for partial performance, like singing a song, hasta lang sa intro tanan, wala chorus, tibudlay na siya. Ngita ka lang pero may away sina. The dance of tinikling, the instances therein, of course, the performance cannot be made as partial. You have to render the entire number or the entire performance in itself. So the rules are deemed indivisible, whether you're trying to give a definite thing or you're trying to perform something. Other rules, obligations intended by the parties to be indivisible, even if the thing or service is physically divisible. Same as what I mentioned, obligation of D to give 1,000 to C on a certain date. Again, money is physically divisible. But the clear intention here is D wants the delivery of 1,000 at one time and as a whole. When is it deemed indivisible? Again, the obligation intended by the parties. Suppose there are two debtors, si D and E. They want to give 1,000 to C. Is the obligation still indivisible? Show of hands if ano. Thumbs up if you would want to show that it is indivisible. Thumbs up. Thumbs up. Sige be? You understand the question? Suppose there are two debtors, si D and E, to give 1,000 to C. Is the obligation still indivisible? Thumbs up if you claim that the obligation is still indivisible. Kadugay. Okay, so muna na. Tatlo lang. Okay ha. The answer is for E and E, obligation becomes divisible because here, delivery of 1,000 can be done in parts. It can be D who giving 500 and E giving 500. For C, the obligation remains indivisible because it cannot be performed in parts. It has to be given in a whole. So look at into the perspective. Both answers could be correct. It is divisible to the part of D and E if you're going to look at it in their shares. It is going to be indivisible on the part of C because it has to be performed in one and in whole, which is the giving of the 1,000. Oh, it wouldn't really matter for him. It's 500 kay E or 400 kay E or 600 kay D. As long as for him, he receives the entire amount. Yes, question. Yes, Brad. Brad, you have a question, no? Cannot hear you. Aray na, okay.
Hello, attorney. Okay na?
Okay na, okay na.
Okay. Bali my question kagin attorney is that since kagin ang question is depende sa perspective if creditor
Yes.
ka or sa debtor kang aside. So if amo na siya question ng attorney do ka ano lang siya generic lang.
No,
does that
the rule is again it is indivisible because we're going to look at it in the perspective of the creditor. So again, suppose D and E are two debtors, give 1,000 to C. Is the obligation still indivisible? Even if you would look at it as physically divisible ang 1,000 because 1,000 again is money, ang rule ta is obligations deemed indivisible sa babaw. So technically, in the perspective of C, we are still going to treat it as an indivisible obligation because, say for instance, ang criteria lang ginada, Bren, is that you will need to deliver the entire and exact amount of 1,000 to C. Even if you know that it can be divided ang sharing ni D kag ni E. So physically, it can be divided between them. Like what as I was mentioning, si E 600 ang iyayang ihatag, si D 400 lang. It amounts to 1,000. But the obligation is indivisible because they cannot compel, remember that the provision, they cannot compel the creditor to receive only a share of what they have. But because it is 1,000 ang ilayang obligation kay C. Now, which is actually a very practical question because in the absence of any categorization of what kind of relationship that D and E has, the assumption is joint, di ba? The joint. They have a joint obligation, meaning they only need to give it in equal shares. For them, joint on their side. But on the requirement of C is that C should receive the 1,000. So again, look at it in this way. I will emphasize over this instance. Color pen, red. 1,000 is the object. Though 1,000 is divisible, 1,000 should be the thing that should be delivered to C. Tsakto hindi? Tsakto. Because that is the object of the contract. They cannot give in separate terms 500 lang ang nakuha nila, 500 lang ang value nila because again, you look into the divisibility of the obligation. You do not look into the divisibility of the object. Again, the divisibility of the object, ang 1,000 pwede nyo ma-divide tag pisoson, tag shinon, tag 20 and all. But the indivisibility of 1,000 is there because C would only receive 1,000 at one particular point. So siguro wala man na din na-indicate nga when and how he is going to receive it. But because the obligation is supposed, again, there are two debtors. The two debtors is to give 1,000 to C. Is it a divisible obligation or indivisible obligation? We judge indivisibility if it can be performed partially. In this question, it cannot be performed partially because C would only need to receive 1,000, not 500 at one point, at 500 from another point. Again, because the rule is, it is an indivisible obligation by the very nature of the obligation, although the object can be physically divisible. I hope that's clear. Again, 1,000 can be physically divided. But it's good that it has raised so that familiar ka mo. Nga the obligation again would really require that ang ibayad mo ya is just 1,000. Whether 600 ang kay ano yung siya tawag, whether 600 ang ihatag kay mahalin kay D o mahalin kay C, ang importante, C gets to receive 1,000 as the object. Okay? So here, other one naman niya. What are obligations that are deemed divisible? Obligations which for their object, the execution of a certain number of days and work. Kunin siya, ang hinambal ko. Obligation of B to paint the house of C. The painting to be finished within 10 days. That's divisible. Carry? Siyempre, because ma-divide niya in different days and different time. That's equivalent to divisibility. Now, the painting to be made within 10 days, here the obligation is needed to be fulfilled when? Here the obligation need to be fulfilled a one time? No. He can fulfill it within 10 days. Divisible. Take note, divisible siya. Obligations which have for their object the accomplishment of works by metrics. Say for instance, the reason for this purpose requires the performance of all the parts. An example is that obligation of debtor to make a table which is 3 feet wide, 5 feet long. The obligation of the debtor to B to deliver 20 cubic meters of sand. They are all technically indications that it is still divisible. But in the case, the obligation that D alone is to deliver 20 metric tons, please take note, the wordings is here, D alone to deliver 20 metric tons, you identify it as indivisible. Compare it to the previous one. D to make a table of 3 feet wide and 3 feet long. The obligation of D to deliver to B 20 cubic meters of sand. And there is no qualifying statement here that it should be delivered in one point and in one time. Ano ang clues nyo? Pwede siya divisible because there is the indication of work to be accomplished by metric units. Divisible siya. Okay? Deemed divisible naman again, ang clues nyo for this one. Obligations which by their nature are susceptible for partial performance. Teach obligations and contract for 1 year in the university. I cannot do this in one sitting. That's why we have separate dates and schedules. The obligation of E to render 3 songs in a program. Divisible siya. Kahit the songs can be made in separate parts of the program. The obligation of F to pay the debt of 12,000 in 12 monthly installments of 1,000, but each prestation of 1,000 is indivisible. Ang 1,000 niya ang indivisible ha, which is for each monthly installment. But the obligation of the 12,000 in 12 monthly installments is divisible. Okay, ha? Para at least klaro sa atin. So divisibility or indivisibility in obligations do not to do. In negative obligations, not to do na de, ha? The character of the prestation in each particular case shall be determined to their divisibility or indivisibility. Again, this is a negative obligation, and in the negative obligation, how do you define or understand divisibility or indivisibility? Look at it. Obligations to do and not to do are generally indivisible. Why? Because you need to perform the task in whole and at one point. Supposed to be. So the default understanding is if it's an obligation to do or not to do, it is generally indivisible. But please take note, these are your identifying areas. Deem indivisible kung may susceptible for partial performance. Deem indivisible if may ara execution in a number of days or may metric units. Deem divisible siya. Understood as divisible. All right. Obligations to do, they are already provided that they can be what we would consider as divisible in instances under 1225. What is 1225? The one that we just mentioned earlier, the mga metrics, the one with performance in working days and all. Indivisible obligations and obligations not to do. So indivisible obligation, grabe ba, paside yan. A, oblige himself to B, not to sell cigarettes in his store for 1 year. Here, the obligation should be fulfilled continuously during a period of what? 1 year. Indivisible to siya, indivisible obligation. Here, divisible obligation. If the obligation of A is not to sell cigarettes in his store only during what? Sundays and holidays. The obligation is divisible because the forbearance is not continuous. So your criteria for not to do obligations is to identify whether or not they are continuous or not. Say for instance, you are prohibited from selling liquor for the duration of the pandemic or GCQ. Divisible or indivisible? It's indivisible because you're continuously prohibited from doing that within a certain duration. But say for instance, you are going to only sell it from 12 noon to 6 p.m., then that is an instance that you can divide the prohibition because it's not continuous. There is a set of time for you to sell. Following?
Yes, attorney.
All right.
Attorney.
Okay.
Yes.
Sige. What is the true test to determine divisibility? Here, whether or not the prestation is susceptible of partial performance or not in the sense of performance, but it is the sense of possibility of realizing the purpose which the obligation seeks to obtain. If a thing could be divided into parts and as divided, its value is impaired disproportionately, and that is to be considered as indivisible. So, the true test, will it impair the value of the thing? If you will divide it, then you go to the indivisibility. Okay? This is the test to determine divisibility or indivisibility. Of course, your default here is that whether it is prohibited by law or through the agreement of the parties, but your test, again, technically the object can be partially performed. But if you partially perform that, will its value be impaired and cause such disproportion? Then you adopt indivisibility. Okay? What is the primary distinction between divisible and indivisible obligations? It's just this. It's susceptible for a partial performance. The other one, non-susceptibility to be performed partially. Because in an indivisible obligation, partial performance is what? Non-performance at all. Okay? That's its equivalent. Indivisible, pwede kaya ka partially perform, you are not in violation of anything. When may obligation to deliver a divisible thing be considered indivisible? Ang obligasyon mo, ma-deliver sang divisible thing, pero you will consider it indivisible. Answer, when the law so provides by the stipulation of the parties. Same as instance. Answer, para yung reiterate ko lang kay para ma-remember nyo again. Okay? What is the effect of illegality of a part of a contract? In a divisible contract, the illegal part is void and unenforceable. The legal part is valid and enforceable. This is what I was telling you. If, say for instance, you can divide a particular contract or a particular obligation, the objects of which that are to be considered illegal shall be void or unenforceable. But as long as there are objects there or parts of the contract that is still valid, not violative of the law, then you can perform it. But here, if it is an indivisible contract or an indivisible obligation, the illegality of the particular object will render the entire contract unenforceable and void. Entire contract is indivisible and unenforceable, meaning it is void. Tanan, kabilugan ng kontrata. There are instances where in a contract enters into may mga provisions na valid. There are provisions that are actually kumbaga violative of certain constitutional provisions, civil law provisions, labor law provisions. But if it is a divisible contract, only those that are void will be disregarded. Those that are valid will be considered as proceed with legal and binding effect. All right. What is the effect of partial performance in an indivisible obligation? You already know this. Partial performance tantamounts to non-performance. Okay. So that is very much as an essence of it. Wait. Discard. Okay. Let me now proceed to the last topic. This is more entertaining actually. Sorry ha, I know that it was very heavy for you to spare me with the pamatis ito. But this one, I really love discussing this Lapit na lang. 30 minutes na. Joint and solidary obligations. Okay? Here, we already know the different elements of an obligation, di ba? We have active, passive, object, prestation, or what we call as vinculum juris. So, apat. Now, we're going to do with the persons involved. Kagina sa divisibility, kag indivisibility, ang ginalokta is actually the object or prestation. Diba? We're studying what if the object is susceptible to partial performance? What if the object is not susceptible to partial performance? So we were focusing on the object. This time, we're going to focus on the persons involved and their relationship with each other, whether active or passive subject ka. So here, we have parties involved. The parties may either be individual or they may be collective. So in a perfect world, the easiest part is individual parties, one-on-one. So kinds of obligation according to the number of parties involved. Only one obligor and one obligee. Usapos. Why na may manada? But what if there are two or more debtors and two or more creditors? What will happen to you? But in reality, there can really be two or more creditors and debtors that are entering into agreements. There are several parties involved as debtors, several parties involved as creditors. One-on-one from multiple collective parties. Okay, so here's your checklist. Please take note, in identifying the problem, identify who are the persons liable to pay. Then, who are the persons, when you are identifying who is the person liable to pay, you are identifying the debtor or the obligor. Who are the persons entitled to demand payment? You get to know who is the creditor. What is the extent of the liability of each debtor? What is the extent of the right of each creditor? Checklist nyo so that mas makaposin nyo. You're dissecting the very essence of the problem. So here, only one debtor and one creditor. Tapos lang. One debtor, one creditor. Isa lang. Tapos. Who is, in this example, who is the debtor? Siyempre sino siya?
Wolverine.
Yeah, Wolverine. Siya, si Hawk.
The Hawk.
Okay, si Hawk. Persons entitled to pay. Si Wolverine. Who is entitled to demand payment? Si Hawk. Extent sang liability ni debtor? Wala, given. Wala. Ang extent sang liability niya is not provided, but whatever it is, because he is the only debtor, he will answer to all the obligation. And the extent of right of the creditor, because he is the only creditor, anything that is due to be paid, siya lang na iya ang makademand, kag siya lang ang makabaton. That's so easy. Now we go to the headache part, the collective obligation. Say for instance, all of these individuals involved. Let's define first joint obligation, where the whole obligation is to be paid or fulfilled proportionately. So the essence here is proportionately by the different debtors, or it is to be demanded proportionately by the different creditors. Okay? So proportion does not necessarily mean equal share, but when you have a default joint obligation, you assume it's equal share. Okay? So proportionately. So coming from debt number 1, number 2, 3, and 4. Apat kabilog, the entire debt percentage of how much do they have. So here, joint obligations, it is always in equal share. That's the default understanding for our proportionate share. if it is not specified, ha? Equal share siya. The share of each in obligation can also be specified. So the different debtors will have, say for instance, sa entire amount, debtor 1 will get 15. 21% sanging borrow niya nga 1 million. Si debtor 3, 330,000 ang nakuha niya. Same man kay debtor 4. So in part of it, you are actually designating specifics. Okay? So here, A, B, and C, they borrowed 9,000 from isa lang kabilog na tao. And that is Batman. So, if we are going to apply the rule that joint obligation ang ini nga mga debtors, debt. How much should each be liable for?
3,000.
So the rule is usually the entire amount divided into how many debtors? Divided by
3.
3. So each would be assumed to be liable for the amount of shucks, limutan ako maglagay pong debtors. All right. Nonetheless, so the presumption is joint can only be demanded from each of the debtors 3,000. X can demand and collect the amount due, which is only 9,000. But for each, say for instance, Batman goes to Green Lantern, Lantern will only pay 3,000, 3K. Superman, 3K.
Flash.
Si Flash, madlagan lang
3K.
si Flash. Madlagan lang si Flash. Pero 3K yapon. Okay? So that's the basic. What if Suleonda naman? What if si X naman niya, which is Batman, ang naghulam sa tatlo ka creditors? A, B, and C. Debtor is si X, creditor sila. How much ang balayran ni debtor? 3,000, sir. Hindi, 9,000 gid yan.
9,000 yun.
Oh, kay siya lang yan mo ang
Tingog bayaran.
siya lang ang nagtingob utang. Okay? For each of them, they can only demand as much as to their share, which is the joint presumption. There is only one debt. 3 of them will be able to get 3 credits. And each creditor can only demand the share from X. Hindi na siya A. X. 3K lang yapon ang makuha ko. So kung nagtabok ka from creditor, instead nga 3K nga balayran, 3K nga balatunon mo. Okay? Di ba kay ang creditor ya hindi na siya mamayad, mangulekta na siya. So that's the very objective niya. Okay? Sige, what time na ba? Dapat pa. Tapos na rin.
Anong ginagawa mo sa bibi ko?
Anong ginagawa ko sa bibi mo? Sino naman? Dorothy? Ang bibi mo ipahimo sana kay mo tadi siya karon creditor.
Hello, sorry, sir.
Okay. So this part natabunan si Hulk. But this time, it's actually Hulk and Wolverine naghulam sila ya sa creditor nga si Iron Man. And si Batman. Okay? Still following, kay di duwa-duwa na ni siya. Let's presume again that all the obligations is joint. There is only one debt, which is 9,000. the total liability of A and B, for this instance, si A, this one is B. Okay? In this point, you have to understand joint. Pila ang debtor? Duha bilog. So you just simply divide this into
2. 4, 5.
so tag 4, 5. Wow. Hindi ka mo ma-intimidate sa numbers. Hapos lang niya. Kaya ginahatag sa inyo numbers man lang pareho. 4, 5 each. Now, kung magtabok naman niya for the creditors, joint man lang siya, pila ang makwa nila? They can also ask for the share and value. Karon na anay. Surprise anay. Wait. They can also get the value, say for instance, sa 9,000, he can ask for the 4,500. I-divide mo anay sa ila 4,500, 4,500. Because that is the amount that they can ask for each other. But for the 4,500, this is to be given by Wolverine. I-divide niya pa ni to the number of creditors. So, the total amount divided by 2, which is the creditors. Ang creditor, pwede, ang iyang share is to be divided by the number of creditors. So, the 9,000 is divided to 2 because the 2 is the number of your debtors. Amo na siya nag 4,500 siya. Now that the 4,500 is here, each of the creditors will receive how much?
250.
Yes, correct. 2,250 ang due. Butang ta si Wolverine will need to pay the entire utang niya nga ibayad is 4,500. But if he needs to apportion the 4,500, ang ibayad niya supposed to be is 2,250 makadto kay Batman and the other 2,250 makadto kay Iron Man. So this is just the simple arithmetic that you need to understand when you're going to compute the liabilities for joint. There shall be as many number of creditors as to be paid to as many numbers of debtors. Sorry, that should be 4. I hope you're still following. Kaya again, it's very simple. Ang gingutang nila ni Wolverine kag ni Hulk is 9,000. Now, the presumption is that joint ang ila liability. So they will only pay the share of what they have, which is in equal share, 4,545, which is half of the 9,000. But because there are actually two creditors, they can subdivide the 4,500 to the number of creditors that are supposed to be there. So 2,250 intended for Batman, 2,250 intended for Iron Man. Same man kay Hulk, nga ang balayran niya nga 2,250, which is supposed to be in total 4.5K, is the one that he is going to pay. So in whole, technically, you are not violating anything because ang gingbayad ni Hulk is supposed to be 4,500 lang gid man tanan ang iya liability. Are you following? Yes, Gray, Paula.
Sir, for example, sir, sa nga example ng example 9,000 man bigyapon and then inistoryahan ni ang debtor si
Si Hulk kag si Wolverine.
Si Hulk kag si Wolverine niya daw kakulang pa ko ng money ni Wolverine. So si Hulk na lang daw kano ang mas dako mabayad. So bali 5-4 sila. Kaya diba sir, joint is not always equal share.
Oh, so but the caveat for that, the warning for that, Paula, is that should be prior arranged. Meaning to say, it is recognized. Amo lang ni gani ginaanon ta kay we're just making the presumption that it is equal and joint. But it's valid that pwede ya 60-40. 60% or like 6,000 ang nakuha ya ni Hulk. Tapos 3,000 lang ang kay Wolverine. So kung mag-amo na siya, paano na i-solve? Simple. The 6K,
the same Japan, sir.
yes, the 6K
Divide Japan too.
will divided by the number of creditors. So 3K will go to Batman and the other 3K will go to Iron Man. So for him and his part, he can pay 3K divided by 2, 1.5. Ang 1.5K bayad niya kay Superman, kay Batman kag kay Iron Man. Okay? Simple. Alright? Amo lagi ding rule sa joint. The rule of joint is that you have to divide it to the number of creditors. Una-una, ang rule is you divide the obligation to the number of debtors. Joint ni siya ha. Kung duwa ka bilog ang debtor, divide mo siya to the number of debtors. And then once that you have already the result or the product of the division nga 4-5, you then divide it to the number of creditors. That's the value that you will get to pay for each of the creditors. Entitled. So Batman can demand 2,250 to Wolverine alone. Batman can still demand 2,250 to Hulk alone. Okay? So in total, what he can ask is the amount of 4,500 for each. For all of the debt, which is 9,000. For each naman niya, amo to, 2,250 ang pag-subdivide. Okay? Following pa? Sige. My other exercise is this. What if, ari naman, 3 ang debtors ta. 2 ang creditors ta. Here, you just simply follow the rule. You divide the entire amount to the number of debtors. Pila ang number of debtors ta? 3. Then you will be able to get how much kada isa? 4,000.
4,000.
So, isa kada isa, mabayad 4K. Sorry. Si Batman, mabayad man. Si Superman, mabayad man 4K. Si Flash, madlagan, pero may utang siya yapon na 4K. Okay? Total of. Now, you divide what they owe to each other, what they owe, divided the number of creditors na pwede nila ibayad. Technically, ang liability ni Superman niya 4K. So, it's just a matter of designating pila ang ma-demand sa kada isa creditor. So, here, you see that 4,000 is divided by 2. The debtors due, which is 4,000, is divided to the number of creditors that you have. And so technically, 2,000 is the amount that each creditor can collect and demand to each debtor. Batman can demand the amount of 2,000 to Flash, 2,000 from Superman, 2,000 from Green Lantern. Because technically, if you're going to cross to the side of the creditors, 12,000 divided by how many creditors? 2. 6K ang pwede nila makollect. Okay? each, di ba? 6K ang pwede nila makollect. But because we have 3 different debtors, sa kada isa ka debtor, pwede niya lang yung ma-demand is 2,000. Following, the creditor cannot collect from each debtor more than the corresponding share in the obligation. That's because their individual liability, like Green Lantern owes 2,000 to Batman, and Green Lantern owes 2,000 to Iron Man, because his whole liability is only 4,000. Same that Superman only owes 2,000 to Batman, 2,000 to Iron Man. Same with Flash, only owes 2,000 to Batman, only owes 2,000 to Iron Man. That's their individual liability. Okay. So rules under joint obligation. Let me just finish this. There are as many debts as there are debtors. There are as many credits as there are creditors. That's why you divide. Each debtor is liable only for the proportionate share of his debt, and the debt or credits are considered distinct and separate from one another. Each creditor is entitled only to the proportionate part of the credit. That's why kung mapautang ka mo, very convenient that you make it a solidary obligation. Kaya nga kaysa lalagson nyo si Flash, si Superman, kag si Green Lantern, isa lang sa ila kadtuan mo, bayaran na nila dayon ang share mo. Or you can already demand the entire obligation to them. But because, again, the law does not assume higher assumption of liability, the minimal liability is joint, which is only a proportionate share of what they can receive. Therefore, amo lang na ang pwede nila makuha. Amo lang na ang pwede nila magamit. Okay? Next, absence from law or nature wording to be solidary, it is to be default joint. When the debt is distinct and separate from each other, the insolvency of one of the debtors shall not make the others liable. Are. Say for instance, mabalik ko na isang insolvency nga part, ha? Say for instance, si Green Lantern, hindi na siya kabayad kay nadula niyang iyang ring. His insolvency is only to his part. Insolvent meaning wala na gid siya tsansa makabayad. Does it mean that the 2,000 that he owes to Batman will be distributed to the 2 others? No more. His insolvency will no longer affect the others, and his debt is only distinct and personal to him. Meaning to say, he will not be able to pay. His debt will not be charged or transferred to the other debtors with him. So as if wala na ni siya. May mahimo. Because under the law, insolvency of one of the debtors shall not make the others liable. Creditors can only demand the particular amount. The motto again is to each his own, or your very own KKB. All right? Okay. Sa solidary, very quick lang niya kay Ted. Each of the debtor is bound to render as if it is the whole and entire compliance of the prestation. So with that, I end it here so that you would understand. I'll further discuss solidary so that makarest ang brain nyo. I hope you learned something, at least papano, maski jutay. You get to discover that, you know, in reality, damo gidya, I mean, in one point in your life, or even right now, you would understand people are actually borrowing money, not understanding how much of their liability is being affected. So, amo na, kung makabasa ka mo contract about lease, loan, and everything, you identify anong liability nila. Liability nila is only joint. So each divide. Oh. Ang ma-divide mo lang na siguro. Sorry ha. Sorry kung not saying nga mama or something nga sa parente nyo or tita. Ang debt mo is only this amount. Hindi na nila mapangayo ang entire amount. Okay? So you could advise them properly. Kaya under the law on obligations, ang obligasyon mo is only limited to what you have proportionately received or shared if it is a joint obligation. But kung solidary yung obligation, akigan nyo. Nga nagpasugot ka man nga solidary yung obligation nyo. Yan. So kung mangutang ka mo, ensure nga joint lang rather than solidary. Okay? So I hope you learned something, at least maski pa paano. We will jump into other topics next time we meet. Okay? So the next time we meet Monday, can we have a meeting on Monday or we go through with Wednesday lang gyapon? Ano sa inyo? Wala tayo exam buwas asa next week ha. Na-discuss pa tayo gyapon sa topic. Anong gusto nyo? Any suggestion, Jackie? Wednesday lang?
lang ko, attorney.
Ano?
Exam. Attorney,
May exam na ka mo? Oh,
And may
wala. But can we still meet next week?
Yeah, sa Wednesday lang ito.
Wednesday on the same class. All right, no problem. All right, leave Jesus in our hearts.
Forever.
Forever.
Thank you.
Thank you, attorney.
Thank you, attorney.
Bye.
Thank you, attorney.
Attorney, sorry again kagina.
Bakit si Muda, Dorothy? Ikaw gid pare.
Sorry.
Iparecite
Promise, sir, nagapamati ko. May
Iparecite
screenshots ko po ganito to prove it. Sorry again, hindi maliwat.
Okay, bye-bye.
Thank you.
Attorney, thank you.
Thank you, good.
Attorney, pwede pa ko kapamangkot, attorney?
Ano na siya, Fel?
Do ka outside naman sa topic, attorney, about sa, let's say, attorney, ikaw ang creditor, ako ang debtor. If hindi ko mabayaran ang akon utang sa imo, and what are the possible ways nga we can do para mapilit natin nga makabayad ang debtor?
Ano ka siya nangutang si mo?
Yes, attorney.
Paano siya nangutang si mo?
Let's say, kwarta.
Okay, amo gineo, kung gapautang ka, make sure mo ang gapangutang si mo ma-issue cheque. Okay? Kaya kung mangutang lang sila nga wala sila sang collateral or anything, then chances are default in payment, you cannot go after them. Pero kung gapautang ka, make sure nga kung may mangutang sa imo, pa-issuehan mo sila cheque. Kay in instances nga hindi sila kabayad, sa guarantee note nila, there is a criminal liability involved by the bouncing checks law. So, more than just the civil liability of not being able to pay their obligation, you can go after them under a criminal case of BP22 for not paying through the bouncing checks. Nga syempre nagtalbog ang mga and that's considered as a criminal offense. Amo na siya usually, it has a higher deliverable performance because kung hindi siya magbayad, mapriso siya because of the bouncing check. But technically, mapriso siya kahit wala siya nagbayad utang. So muna nila kung mangutang ka, wala man niya may gakapriso sa mga tao nga gapangutang. Duwa lang ng exception. Kung nangutang ka, nga ang gingamit mo cheque ang guarantee, tiyak ma-priso ka because of the bouncing check kaya wala mo na punduhan. Kadua, pwede kaya nga maka-establish ka nga ang ini nga tao nangutang si mo nga may dala nga pagpanginto because that now translates to a felony which is estafa. Ang estafa naman niya, ang elements ng estafa is fraud and deceit. Meaning nangutang siya nga may pagpanginto nga bayaran niya ka sa ina nga oras, sa ina nga tsimpo. So kung hindi niya na mamahimo, kag ma-prove mo nga may pagpanginto, then pwede mo siya yakasuhan estafa. So amo na dapat ang imo nga. Pero sa mga instances pareho sina sa mga credit card na bla. Provision na sa credit card nga that the holder of the card guarantees that he has capacity and willing and ability to pay within the designated period for it. Otherwise, he shall be held liable for deceit or estafa. So usually, muna, ng banks go after those who are unable to pay by reason of the fact nga may ara imposition of ano ni siya, deceit, which is estafa. Okay?
Attorney, thank you gid so much.
Thank
gid,
you.
attorney.
Thank you, Fel. Sige.
Thank you gid.
Paway,
Daway
paway.
ko na balaan. Thank you.
Halong, halong.